Hi, everyone. My name is Andrea Chavarria, and I'm an immigration attorney. Today, I want to talk to you about marijuana and immigration and how marijuana can affect you. And in terms of marijuana, we're not just talking about marijuana usage. If you have considered investing in marijuana, if you have worked or are considering working in a field in the cannabis industry, please know that that could affect your case if you are seeking either residency, citizenship, or some sort of immigrant or non-immigrant visa. I'm going to go through a list of questions that people have sent to us, and I'm going to address some of these questions and just give you a little bit more information of how marijuana can affect you in your immigration case. Now, one of the questions is, if marijuana is legal in my state, can I still be denied a visa or green card for past usage? And the answer to that is yes. And so what a lot of people don't know, especially in states where marijuana is legal, is that marijuana is still illegal federally. What that means is, even though states have said, yes, it's legal in our state, if you are trying to obtain an immigration benefit, which is federal, that is going to affect your case. And that is extremely important for those of you in particular who live in these states where marijuana is legal. We have seen the consequences that someone can suffer because they were not aware that this could affect them in terms of marijuana being still illegal at a federal level. So yes, even if it is legal in the state that you may live in, or even outside the U.S., if you live in a country where it's legal, that could affect you if you're seeking to obtain some sort of benefit here in the United States and you disclose that marijuana usage. Now, another question that we have is, can using marijuana or holding a medical marijuana card hurt my citizenship or naturalization case? And the answer there is yes. You don't necessarily have to have a conviction in order for the marijuana usage to affect your naturalization case. In terms of those who are seeking to become U.S. citizens, in other words, you're already a lawful permanent resident and you've applied for your citizenship, if you admit to usage, that could affect you in terms of showing or lacking good moral character within the 5-year period that's necessary. And again, this is extremely important for cases where we normally see this where a state has legalized marijuana. And what we've seen is that at these interviews conducted by immigration officers, they can and will ask you, especially in these cases where the state has legalized marijuana. So you're not in the clear if you're a lawful permanent resident. Your marijuana usage can affect your ability to obtain U.S. citizenship. Again, that can affect you in terms of lacking good moral character. Now, another question that we have here is, what if I've never been arrested? Can just talking about past use be a problem? And as I mentioned, yes. If you're, for example, seeking lawful permanent residency and the officer asks about any potential unlawful activities, even if you were not arrested and you admit to the usage of marijuana, that is going to affect you in terms of this good moral character. And we're not talking about just simply, it could be something as easy as saying, oh, yes, I smoked marijuana a week ago at a party. That can have that negative effect with your citizenship case. Now, even if you were not arrested, that can also affect you if you're seeking, for example, a non-immigrant visa. A non-immigrant visa is one where someone is asking the government to allow them into the U.S. temporarily. We usually see this in the context of a tourist visa or perhaps some sort of employment visa. And if you do disclose this, then there are going to be, your case can be denied because, again, you are disclosing something that is considered unlawful activity here in the United States. Another question that we have is, I work or I want to work in the state legal cannabis industry. Is that safe for non-citizens? The answer is no. If you are not a U.S. citizen and you are thinking about working, or you work in the cannabis industry, that can be either working in the field, it can be working in a shop or owning a shop, that can truly affect you in your case in terms of either getting your residency, your citizenship. We have seen the cases where the officers have denied these cases because you are engaging in an activity that they see as illegal or unlawful, even though the state has said that it's lawful. So if you are cultivating, selling, manufacturing, the government is going to say that you are conducting an illegal activity, and that is going to affect your immigration case. Our strongest advice right now for those who are seeking to obtain some sort of immigration benefit and are not U.S. citizens: do not work in the cannabis industry, because that will affect your case. Another question that we have is, do any waivers exist for marijuana offenses? Yes, but this only applies to certain cases. So there is a waiver that does exist, and the rule is that if the person has been convicted of 30 grams or less of marijuana, that person can file a waiver if they can show extreme hardship to their qualifying relative, which would be their spouse or their parent who's a U.S. citizen or lawful permanent resident. This waiver obviously isn't 100% guaranteed because you are going to have to show that hardship. The other thing is that it only waives one conviction of 30 grams or less of marijuana. If you have 2 convictions or more, unfortunately, that's going to affect you because you're not going to be able to waive the other convictions. The U.S. government, even though the states have become more progressive in terms of acknowledging states have become more progressive in terms of the usage of marijuana, but the federal government still has a very conservative view. And so even these 2 convictions of marijuana, as I mentioned, will affect your case. And that's if you're seeking to become a lawful permanent resident. And that's where it would be considered inadmissible, and you would have to file this waiver. The waiver has to get approved in order for you to obtain that residency. So these are serious consequences that you can have if you're trying to obtain lawful permanent residency. Now, another question that we sometimes get is, does President Biden's cannabis pardon protect non-citizens? The government was very strict in their limitation of these pardons, and this only applies to U.S. citizens and lawful permanent residents. So if you were here in any other type of visa status or here undocumented, unfortunately, you would not benefit from that pardon. Now, another question, what about drug abuse findings by a civil surgeon or panel physician? And this is extremely important because when someone is trying to obtain their lawful permanent residency, sometimes they have to go abroad or they live abroad and they have to go to their interview with the U.S. Embassy or U.S. Consulate. When the person has to do that, they have to get a medical exam authorized by a medical clinic or physician authorized by the U.S. government. In that medical exam office, they will ask you questions. The government wants to make sure that the person does not have any issues in terms of alcoholism or any drug or substance abuse issues. And we often see this in certain embassies or consulates. We see this a lot at the interviews in Ciudad Juarez in Mexico, and we also see this sometimes in other ones such as San Salvador in El Salvador. And basically, the physician can ask questions if, for example, have you ever tried marijuana or have you ever tried any drugs? And once they start asking these questions, and depending on your answer, that can open the gate to more questions where they could have a finding that they believe that you have some sort of drug abuse issue or a health issue, and your case can get denied because at that point, the medical doctor will disclose that information to the embassy, and they wouldn't be able to complete that medical exam. So what you tell the medical doctor and their staff at that interview is extremely important, because those words have consequences in terms of you being able to get your residency. So it is extremely important, if you find yourself in that situation where maybe you do have a medicinal card, or maybe you have used marijuana in the past, or you are currently using marijuana, it's extremely important to consult with an immigration attorney, so we can advise you as to your rights, the risks, and the consequences of what may happen if you proceed with your case. Once there's a denial, for example, at the U.S. Embassy or consulate because of this drug usage or marijuana usage, oftentimes a person will have to wait outside the United States for a year, which can be very devastating for families where the applicant was already living here in the U.S. and simply was going outside to attend their interview and come back with their residency. So that is extremely important for those seeking that residency abroad. Now, another question that we have is, what should non-citizens do right now to stay safe? And I have some guidance or key points here for those of you who are not U.S. citizens and are thinking of either joining the cannabis industry or have perhaps used marijuana in the past. So one very important is refrain from marijuana usage and employment in the cannabis industry. And I cannot stress this enough, that this includes working out in the fields, selling, investing in a company. All of that can affect you. And we've even seen cases where sometimes someone has worked as a subcontractor for a cannabis company, and immigration was basically denied their case because they associated that with them working in the cannabis industry. So again, you should avoid at all costs marijuana usage or working in the cannabis field industry while at this moment until you become a U.S. citizen. Once you become a U.S. citizen and you've naturalized, at that point, if you're interested in working in the cannabis industry, that's fine. You're allowed to do that. But while you're on your pathway to U.S. citizenship, I strongly advise to refrain from working in that field. Another thing would be, if there is a medical need, and we do understand that sometimes because of medical reasons, the person needs the medicinal card. Well, one is speak to an immigration attorney. We are here to advise you, again, of the consequences of the marijuana usage. The U.S. government still says that marijuana is illegal. So even if you have that medicinal card, that will affect your immigration case if you're not a U.S. citizen, or if you're thinking of becoming a U.S. citizen. And another thing is, if you have this medicinal card, another thing that we often talk to these clients is maybe talk to your doctor and see if there is another alternative treatment or an option. And we understand that, again, depending on the person's medical history, treatment, and how it's going, sometimes that medicinal card is the most feasible thing for that person. So this is something that you would seriously have to think about and determine what's best for you. Now, another thing is, a non-U.S. citizen should refrain from carrying marijuana, a medical marijuana card, marijuana products, paraphernalia, marijuana apparel, or accessories. Now, I know I briefly touched upon those who are wanting to apply for residency or those who are wanting to apply for U.S. citizenship. But even if you are a tourist and you're coming into the United States, if you have your marijuana apparel on you while you present yourself at the port of entry, and the officer there has the authorization to ask you questions. And again, if you openly admit, well, yes, I'm going to this marijuana conference, or I'm going here to go to a dispensary, going to Colorado for a dispensary, that can have severe consequences and your visa could be revoked. So it's extremely important. to refrain from carrying such items with you. Another thing would be non-U.S. citizens should remove any marijuana-related photos from their phones or social media. And no matter the urge, you should continue to keep that content off your phone and off social media because, again, these are things that the U.S. government can look into and they can search if they want to. And again, we're talking about not just someone applying for U.S. citizenship or residency, but we've seen it in situations at the port of entry or at the airport where the person is asked further questions by the officer. Another thing is a non-U.S. citizen should never discuss any marijuana use or possession with any immigration, border, or law enforcement authority. If they're asking you questions, you do have the right to remain silent. Anything you openly admit to any immigration officer, whether it's at the port of entry or it's at an interview, whether it's here at the local U.S. Citizenship and Immigration Services Office or at the U.S. Embassy or Consulate, or as I mentioned, with the medical doctor getting your exam for immigration purposes, anything you say to any of them can be used against you in order to deny you your immigration benefits. So it's extremely important. I know sometimes you go to, clients have gone to interviews and they think, okay, this officer is really nice. Yeah, I'm going to just say, yeah, I went to a party yesterday and I smoked marijuana. That is going to affect your case. And what we've sometimes seen is when the person goes to their interview here with U.S. Citizenship and Immigration Services, the more the person starts disclosing, the officer can video record the interview. They can also have the person take testimony, and then have the person sign attesting to what the person has stated under oath, which again, these are things that can affect your case. Now, another tip is if a non-U.S. citizen has to attend an interview at a U.S. embassy or consulate and requires a medical exam, they should be prepared for the examiner, as I mentioned before, to ask about any drug or alcohol use. And so this is extremely important. I cannot stress enough that what you tell that medical examiner, what you tell their staff, it is not confidential information. That is information that can be relayed to the U.S. government. And unfortunately, we've seen these situations where the person, their immigrant visa was denied and they've been stuck abroad for a year or sometimes longer because of this admission. I know a lot of clients sometimes are confused because if you go to certain states, it's legal. Everybody that wants to partake has the capability to do it in that particular state. But if you're not a U.S. citizen, you do have to understand that, unfortunately, you don't have the same right as a U.S. citizen when it comes to marijuana. U.S. citizens have the right to participate in the usage, possession. They have the right to invest. They have the right to have a company or work for a company or work in the cannabis field. But if you're not a U.S. citizen, you unfortunately do not have that right. And that is because immigration law is federal and marijuana usage is still illegal at the federal level. So until that changes, unfortunately, marijuana usage, working for the cannabis industry is going to affect your case if you want to become a resident, citizen, or even just come visit the United States. If you believe that you may have an issue with your case in terms of your residency or citizenship, it is advisable to speak to an immigration attorney. We can assess your case, and like I said, we can go over the consequences, the risks, and your options that you may have. Now, lawful permanent residents, if you've been convicted of a conviction of marijuana, depending on the conviction, when it happened, And if you travel outside the United States or remain in the United States, there are certain situations where a lawful permanent resident, if they have certain marijuana convictions, travel outside the United States and try to re-enter, there are situations where that person could be detained and placed in removal proceedings. So if you're a lawful permanent resident and you do have a possession of marijuana conviction, it's extremely important to talk to an immigration attorney, especially if you are thinking about traveling outside the United States. The other thing that I want to talk about is if you've been arrested for marijuana, it's extremely important to, one, talk to a criminal attorney, but also to talk to an immigration attorney. Not all dismissals are equal in terms of the immigration context. So in certain cases, if you have been convicted of marijuana, but your case was dismissed through pretrial diversion or through deferred adjudication, your case is still going to be considered a conviction for immigration purposes. And a lot of clients, unfortunately, don't understand that. And so again, it's extremely important if you find yourself in that situation where you've been arrested, you've been charged with possession of marijuana or any sort of marijuana-related offense, it's extremely important to talk to an attorney, a criminal attorney, and immigration attorney, because sometimes a criminal attorney could say, great, we can get you a dismissal, we'll put you under deferred adjudication or pretrial diversion, without realizing that even though that may be dismissed in the criminal context, it'll be considered a conviction for immigration purposes. Immigration law is a very complex area of law. And so that's why we're here to talk to you and just give you some tips on things that you can maybe do or ways that certain activities can affect your case. Because if your end goal is to get residency or U.S. citizenship, we want to help you and help you understand that there are certain things that can affect you when you're seeking such benefit. Now, if you or a loved one are facing certain offenses, drug-related offenses such as drug trafficking, or a felony-related offense, a felony offense related to drugs, then at that point that can have also severe consequences. Not as the drug trafficking one can have consequences not only for you, but also for loved ones, say maybe your spouse or your child, if you're trying to apply for them to get a benefit. If the government if they're able to show, or if you have the applicant, let's say your husband got convicted of drug trafficking and you, the spouse, benefited from this activity within the last 5 years, you benefited financially, well, the government can say that you're not admissible to the United States. So it's not just possession of marijuana that can affect the applicant, but again, drug trafficking related offenses can affect not only the applicant, but also the spouse or other family members if they're also trying to obtain an immigration benefit. And sometimes what we see with these cases is if a family member has been convicted of a drug trafficking offense and the other family member is seeking a benefit, immigration benefit, let's say the lawful permanent residency card, and what we've seen is sometimes the government, especially when it's a consular processing case, meaning the interviews at the U.S. Embassy or the consulate, we've seen that sometimes they'll place the case in what's called administrative processing while they do their checks to double check that this person has not benefited from that illegal activity. So that's pretty much all I have today. If you have any questions and you would like to consult with our office, you can always call us at 972-827-8359. That's 972-827-8359. Thank you.